determining the appropriate sentence in this case, the court has considered the seriousness of the offense, your history, the principle of proportionality, the statutory penalty, the cost of confinement, the report and recommendation of the probation department, as well as what's been said on the record here today. In addition to that, I have reviewed the pre-sentence investigation report. Obviously, I have reviewed I believe I'm up to 10 letters now submitted with the pre-sentence investigation report. I received 7. I received, I think, an additional 3 this morning. I've also reviewed the people's sentencing memorandum, the defense sentencing memorandum, and 15 letters that were attached to that memorandum. It goes without saying that the tragedy of these events is immeasurable. Mr. and Mrs. Warner had a large family. They built up a large business in this community. And I'm sure that there were many happy times along the way. The letters submitted on behalf of Mr. Warner describe him as hardworking, conscientious, and generous. The victim impact statements that I've heard today and that were attached to the pre-sentence investigation report tell a different story. The job of the court is to attempt to balance those versions of Mr. Warner and craft a sentence that is proportionate to him and to the crime that he has committed. Obviously, murder is among the most serious offenses that we deal with, and most would say it's the most serious offense. And for good reason, because of the scope of the loss, which in this case is immense. Assuming that Ms. Warner had an average life expectancy, she had about 29 years of life stolen from her. But it's not just the 29 years that were stolen from her by this act that the court considers in crafting a sentence. It's the impact of the 29 years that were taken from the sons and daughters who no longer have a mother. The 29 years that were taken from grandchildren who no longer have a grandmother. In some cases, will never get to know their grandmother. 29 years of a sibling that doesn't have a sister. 29 years taken from aunts, uncles, cousins, nieces, nephews, and 29 years taken from friends, of which there appear to be many. Of particular impact are the 29 years taken from the daughter that you and Ms. Warner shared together at such a tender and impressionable age. For the sake of her privacy, I will not detail the impacts that this tragedy has imposed on her that I am aware of. Suffice it to say that I have read the letter from Dr. Henry, and it weighs heavily on my mind in determining a sentence that suits the offense and the offender. A sentence that is proportional. The manipulation of that relationship, that she was made to doubt her mother's love for her, is an unconscionable harm that no number on an offense variable score sheet could ever adequately represent. There were a number of statements in the letters I received about closing the chapter, beginning healing and moving on from this tragedy. Unfortunately, this is one of those types of tragedies where the chapter doesn't always end. As Mr. Bach said here earlier this morning, some will never recover from the injuries, psychological harm that they've experienced as a result of these crimes. The court is required to impose concurrent sentences, meaning the time runs together, unless there's statutory authority for imposing a consecutive sentence. The tampering statute in this case, MCL 750.483A, provides that the court may or has discretion to order a consecutive sentence in this case for that charge. And when I consider whether it's appropriate for the court to exercise its discretion in ordering a concurrent or consecutive sentence, first I think about what constitutes tampering with evidence, or what can constitute tampering with evidence. And that is a wide range of actions. Tampering with evidence in some cases could mean shredding a document or flushing some drugs down the toilet, anything done, no matter how small, to conceal the evidence of a crime. In this case, Mr. Warner welded his wife's deceased body into a fertilizer tank where it remained for more than 3 years. So in looking at that spectrum, we are at the most heinous end of what actions might constitute tampering with evidence. I also look at the severe emotional distress that was caused by that tampering with evidence. Although OV4 is scored for this offense, it doesn't take sufficiently into account the scope or intensity of the psychological impacts of the offense. In this case, Ms. Warner's loved ones and friends were deprived for more than 3 years of their opportunity to properly grieve and mourn their loss. Instead, they were doing everything possible to search for her, holding on to some slim hope that she may still be alive. All the while she was sealed into that tomb and left in a barn. A fact of which Mr. Warner was aware and had the ability to end that suffering at any time, and chose not to. Although certainly not as significant as that, I also look at the public and private resources that were required to uncover the crime as a result of the tampering that occurred. Again, the body was concealed for more than 3 years. During that time, a tremendous amount of public and private resources were deployed in an effort to find her. Seemingly an endless amount of searching on various properties in different locations, all of which didn't need to happen but for tampering charge. And so in considering those factors, think it's very appropriate that a consecutive sentence be imposed rather than a concurrent sentence. If there weren't a consecutive sentence imposed under these circumstances, I don't know when it would ever be appropriate. And so for those reasons, I do believe that the sentence at the top of the guidelines is appropriate, and that the tampering charge be served consecutively to the murder charge. Therefore, it will be the sentence of the court that, Mr. Warner, you serve 375 months, 31.25 years to 60 years with the Department of Corrections. You have credit for 898 days served. With respect to the murder charge, you must pay a $130 crime victims assessment, a $60 DNA fee, and a $136 state cost. With respect to the tampering charge, it is the sentence of the court that you serve a period of 17 months to 10 years with the Michigan Department of Corrections. There's no credit for time served on that, and that shall be served consecutive to the sentence for the murder charge. You do have the right, Mr. Warner, to request an appeal of your conviction and your sentence, and to request the appointment of an attorney to assist you with that. The bailiff is going to hand to you 3 copies of a notice of right to appellate review and request for appointment of attorney form. I'm going to ask you to sign the top copy of that form and return it to the bailiff. That simply indicates that you received your copies of those forms. The record should reflect that you have a signed copy of the notice of appellate rights form for Mr. Warner and placing that in the file. Mr. Warner, if you want to request an appeal and request an appointment of attorney to assist you with that, again, you need to fill out the remaining portion of that form and mail it to the address listed in the form within 42 days. Or if you know that you want to fill that out now, we will give you an opportunity to fill that out now and return it to the court before you leave the courthouse this morning. Is there anything else we need to address on the record this morning? Otherwise, go to Ms. Shirley.
No, thank you, Your Honor.
No, thank you, Your Honor.
All right. Thank you. The court will be in recess.
All rise.
There's a whole man's
Oh, okay. Oh, okay. So maybe.
Got it, okay.
Documentary. You were probably too young to recognize this, to remember this, but there used to be a show on called CSI Miami.